welcome to our training about relocation and the related legal issues. I'm going to share my screen. All right. So my name is Stephen Anderson Garrison. I'm a staff attorney at Greater Boston Legal Services. And I'm here with Ann Sheldon. We run the Relocation Counseling Project. So today we want to talk a little bit about what the project is and then give a real broad overview of issues related to interstate or international relocation for survivors of domestic violence.
Thanks. Yeah, as Stephen mentioned, I'm Ann. I'm also an attorney at the Greater Boston Legal Services. Prior to being here, I worked for a couple domestic violence agents. Well, worked for Dove and then Rosie's Place, so not technically a domestic violence agency, but worked a lot with advocates working with survivors. So excited to be meeting with some of you guys today, and also excited that Hema and Jane Doe are partnering with us in this.
Excellent. Yeah, thank you so much. I'm Hema Saring-Saminsky, and I'm the Deputy Director of Jane Doe Inc. And it's really formerly staff attorney at Greater Boston Legal Services many years ago, and currently at JDI. What we do as a coalition is really, we're sort of a convener and thought partner with 60 programs across the state that do domestic violence and sexual assault advocacy work. And it's really great to have you all as a resource here today. And we look forward to sharing this with our membership. So thank you.
Awesome. And we are recording this, so you're free to turn your camera on, but understand if you don't feel comfortable with that. At the end, we'll stop the recording if folks want to ask questions without being on the recording. All right.
Great. So I'll just get started a little bit about the project. So folks might be familiar with the project. It's been around for a little while. It was run by Valinda for a while, our colleague who's currently on leave. And the idea is that it's a hotline providing emergency legal advice to survivors fleeing across state lines due to domestic violence. So there are a lot of issues that come up in these circumstances, especially if you have children, interstate custody issues, for example, whether to get a restraining order, and some safety planning stuff that might come up. And the idea is that, I'm not sure if you're aware, but intake could take a little while at Greater Boston Legal Services. And so our hope is to be able to provide emergency assistance to somebody within about 24, within one business day. And it's separate from the family law intake. As you'll see, it's a separate phone number. We give emergency legal advice, not full representation. And then the other difference between Greater Boston Legal Services general family law intake is that we cover all of Massachusetts. So we're a statewide project. So, sometimes if the case fits our case priorities and is in our service area, we could maybe take it beyond counsel and advice. But if it's like a case out in Worcester, we're happy to talk to that person, happy to give them advice, happy to provide them with brief assistance. And then we would refer them out to legal services out there should they need that. And I should mention too, we have the chat right here. Feel free to drop questions. We'll try to answer them as we go. And then there'll be time at the end to ask more questions if you talk about issues that you guys see coming up. So as mentioned, we have a hotline number, and it's different from the general legal services intake. And the idea is that it kind of gets fast tracked to us. It comes to our email. So there's a hotline number, a toll-free number. It's an emergency voicemail. So it's not, we say hotline, I guess it's really a warm line. And then we're working on an online resource for folks, for advocates such as yourself, to enter in the intake and essentially send it over to us so we receive it in our email. The hope is that that would save a step for the survivor who's calling. If they've already given you all that information and they give you permission to share, then you'll just be like, send it along. But we're working on that. We'll let you know when it comes out.
Great. So who qualifies for the RCP counsel and advice line? Basically any survivor who's fleeing from or to Massachusetts. And as Ann already noted, that doesn't just mean the GBLS service area. We do have income limits of 150% of the federal poverty level, but we have some flexibility here. So don't let that stand in the way of making a referral or suggesting someone give us a call. we'll see what we can do. And finally, as I think Ann already mentioned, this isn't for full representation cases, but we can refer in-house to advocates at GBLS to take a full case if it's in our service area and meets our priorities. Some examples of folks who might be a good fit for giving us a call. This isn't exhaustive, but a parent who wants to flee Massachusetts to live in another state and has questions about how whether they can and what they need to do with regard to their child if they're moving. Another example would be a survivor who just arrived in Massachusetts and is thinking about filing for a restraining order or some other action in Massachusetts. Survivor who has fled from or to Massachusetts and is wondering about privacy concerns about being located by their abuser. Or another example would be a survivor who has fled and has a new or ongoing case in the probate and family court or another court, either in Massachusetts or otherwise, and has questions about how moving has or will affect their case. So now we're going to move on to the substantive portion of the training. This is meant to be a broad overview to help folks issue spot. You'll probably be left with more questions than answers about some of these things, and that's kind of okay. We want to give a sense that this is a complicated area and of what some of the considerations and issues might be. But ultimately, we want to encourage folks to refer people to us if there are questions, because this is a complicated, fact-sensitive area, and it's hard to have a discrete, concrete answer for a lot of these things without the legal training or lots of information. So some preliminary questions that are really important when issue spotting or making a referral are, where does the survivor live? And if any kids, where do the kids live? Where did they live in the past? And this is not just the place immediately before a recent move, but before that as well. And it's important also to consider the specific dates. The timeline is a really important piece of a lot of this stuff. Another important question is there another legal parent, i.e. somebody on a birth certificate after a paternity case where paternity has been adjudicated? Related to this, and also another important issue on its own, is whether the parties were married or are married. And then, of course, if there are any ongoing or historical legal proceedings involving custody or otherwise, such as a restraining order or divorce case. One issue that comes up is child kidnapping considerations. In some cases, there may be a criminal aspect to leaving with a child. This means the police could eventually be involved. This is true in state-to-state moves and international moves. Because of this, we do suggest you refer folks who is moving or has moved with the kid, especially if there's a custody order or determination in the past.
Yeah, and I guess a lot of this is just to kind of, again, to help you guys issue spot. Like, you may not think there might be a legal issue to begin with. So it's helping identify that there might be a legal issue and to have somebody call us to consult with us. And the hope is that we could do it in conjunction with you. You know, you could assist with the safety planning aspects and we could kind of give the legal advice. You know, we recognize too that our laws are imperfect and sometimes the legal advice we give is not what the survivor thinks they need to stay safe. But, you know, we are lawyers, so we do think education and awareness about what your rights and obligations under the law is important. So yeah, in Massachusetts, we have a removal statute. And what is that? It basically means, can I move with my kids? And what we require or what our law requires is that in cases where the parties were divorced or they're unmarried parents, but there is a legal, the other parent is adjudicated a parent. So like paternity has been established, or there's some other voluntary acknowledgement of paternity or adjudication of paternity, that you either get permission from the opposing party or the court in order to relocate. Moving without that is considered a wrongful removal, and it could have some serious consequences for a client, you know, in terms of like the court ordering the child back here, getting the police involved. It could have impact. And it could impact custody or parenting time for that client as well. So that is, you know, the bottom line, that if you're going to move and there is another parent that is adjudicated the parent, you need their permission or the permission of the court in order to do so. There is some nuance here. So that's something that we, you know, recommend that you refer folks to us to talk about. You know, as the slide talks about, there's some nuance around, like, for the child who's resided in Massachusetts for fewer than 5 years. But again, it's just a circumstance where we recommend you refer folks to us, and we're happy to talk through the process.
It's also worth noting, even if the removal statute doesn't apply, a judge could still look unfavorably on somebody moving away. So it is worth considering not only the legal aspects, but the discretionary aspects that a court might consider when they are evaluating a custody determination. All right, the next issue is jurisdiction. And jurisdiction is about what court has the authority to make determinations about child custody issues. Massachusetts has a statute called the Massachusetts Child Custody Jurisdiction Act, appropriately enough. It is modeled after a uniform act, but unlike a lot of uniform acts, Massachusetts is the only one with this particular language. And that's because all the other states and other territories have adopted an updated version of the uniform statute. You can see the citation here. It's chapter 209B in Massachusetts, and the Uniform Act adopted elsewhere is called the UCC-JEA, or the Uniform Child Custody Jurisdiction and Enforcement Act. At the risk of sounding like a broken record, this is a complicated area. We're going to go over some of the basics here, but there's a lot of factors that can come into play when you're talking about issues of jurisdiction. So Massachusetts jurisdiction under the MCC-JA. The first issue in matters about jurisdiction is determining what the child's, quote, home state is. The home state is where a child has lived for the past 6 months before an action is filed. 6 months is an important benchmark, but it's not the whole story. It's notable that the 6-month period includes vacations or temporary absences, and that a state will stay a home state even after a move unless 6 months has passed. So there's a little bit of a window where even after you move, Massachusetts could still be the home state. If there is no home state, and in some other cases, jurisdiction might depend on other factors, including if there is a wrongful removal, i.e. If a child's been moved out of the state in violation of the removal statute that we discussed before. The court could consider where the child has the most significant connections. And this means basically, you know, where they're living, where they have family, where they go to school, things like that. The court can also consider where evidence is located. I guess under a sort of judicial economy analysis that, you know, this is where the information about the child is. So that's why that court should make a custody determination. And finally, there are circumstances where a state can take emergency jurisdiction, you know, such as in cases of domestic violence or otherwise where it needs to step in right away, even if it's not necessarily otherwise the best state to make a determination like that. One big difference, and probably the most notable difference between the Massachusetts statute and the updated statute that's adopted by other states, is that other states will keep jurisdiction if they make a custody order. So that means if you get divorced in New York and New York says that child custody will be with the mother, even if you move away properly under New York's removal statute, whatever that might state, and even if more than 6 months has passed, New York is still going to have jurisdiction. That can be changed if there's a good reason to do so under some of the analysis above. But that's same thing isn't true for Massachusetts. If you properly leave Massachusetts and no one files anything for 6 months, Massachusetts loses jurisdiction, and the state that you're in will have jurisdiction.
And that, just to add on to that, one thing to think about is how the Massachusetts law in that regard is more favorable to survivors fleeing. That they don't necessarily, I mean, there is a circumstance in which they could flee for their safety, and then 6 months passes, and then the case is where they are. You know, there are pros and cons, right? Every fact is different, but yeah. So staying safe. So yeah, so now we're just, so that again, I think recently, Stephen and I were working on this relocation case together, and I think you emailed me, like, my head is spinning with some of this stuff. Like the interstate custody jurisdiction is so complicated. So we don't expect you guys to like be experts in it by the end of this. I mean, I feel like it's like a constant learning process and relearning process for us, but it's just to highlight that the law is really complicated, and just to help you understand some of the questions you might want to ask before making a referral.
Yeah, the importance of dates, in particular, you know, when moves happened and where people were, things like that.
Yeah. And so, and then there are some legal tools, as I'm sure you guys are really familiar with, around helping a survivor stay safe when they've fled. You know, some of these are restraining orders, impounding an address in a new or ongoing court proceeding, and the address confidentiality program. So yes, restraining orders. I'm sure you guys know restraining orders very well. So this is, you know, a tool that I just highlight here, because it's often when somebody flees to Massachusetts, it's often the first thing that they think about. I want a restraining order. I want to keep myself safe after I've fled. And as I'm sure you know, there are pros and cons to thinking about this. And definitely some questions that you want to ask when you're working with somebody about whether or not a restraining order is a safe tool for them. Here's the definition of abuse under 209A, which is our restraining order law. So, you know, I'm sure many of you know this as well: attempting to cause or causing physical harm, placing another in fear of imminent serious physical harm, or causing another to engage in involuntary sexual relations by force, threat, or duress. So here's, you know, the relief available. I really just highlight this because some of this relief, not all of our judges are really aware of. So, so you have a stay away order, a no contact order that can include the children as well as the survivor, custody order, which is helpful when we talk about interstate custody jurisdiction, parenting time. Bring this up because it's only available in probate and family court. It says so in big bold letters on the form, but district court judges do not have the authority to order parenting time. No abuse could be another, is also relief available under 209A. Child support, again, I highlight this because both child support and compensation are not areas that we see a lot of, and I think it's kind of like one of those like chicken and the egg things where it's like we want to encourage folks to keep asking for child support and compensation in district court because it could keep them out of probate court and keep, you know, address their initial financial security. I mean, whatever. But we don't see it that often. So I think there is a court form to fill out when you want child support, even in district court. Compensation, you think about like, did client miss work because they had to come to court? Do they really did medical bills? Like, did they lose money as a result of the abuse? And kind of seeing if you could make that case. But as I mentioned earlier, there are considerations around whether or not restraining order is a good option for a survivor, even if all of this available relief seems great. Sorry for all the dings. So one thing to think about is, can this be risky for a survivor? So in every state, whether or not the survivor seeks a restraining order here or in another state, there are notice requirements. What that means is, I'm sure you're familiar with, the other side needs to be served with the paperwork. So say you fled from California and you moved to like Everett. Oh, wait, no, let me think of a state. Chelsea. I was like, let me think of a place where I know the district court. Chelsea. So then in order to get a restraining order in Chelsea District Court, the opposing side, or you have to serve the opposing side. So the opposing side is served with paperwork by the police that say that the survivor is seeking a restraining order against them in Chelsea District Court. May not say the address if the survivor impounded the address, but it will say where they are. And so there are some circumstances where that's not a safe option for a survivor. So that's just something to think through when advising getting a restraining order. What if the order, there's also the consideration of like worst case scenario, what happens if then the order isn't issued? So you've just alerted the abuser in California that you're somewhere around Chelsea, and then you also don't have the restraining order protecting you. And then again, there's the consideration in all circumstances. Not all abusers are just deterred by a restraining order. So just being client-centered and deferring to a client for what the client thinks will keep them safe is a number one priority. This is where we get to talk about the Constitution. As you probably know, a restraining order from another state is given full faith and credit in Massachusetts, or like a Massachusetts restraining order should be given full faith and credit in another state. So if a survivor has an out-of-state restraining order that's currently in place, they don't need to get another restraining order here. It's confusing because if they wanted to register it, so be part of our statewide domestic violence database, they would go to court to do so. So they might be like, oh, well, I'm here to file a restraining order. But what they want to do is they want to file a certified copy of the order along with a sworn statement showing that the order is currently in effect. But under Massachusetts law, they don't necessarily have to do this. They're not required to register a restraining order in order for it to be like protect them, right? Having a copy of the order that they're available to show the police should be enough. Is it always enough? Sometimes it's, clearly this, as we've been saying over and over again, this area of the law is confusing. So sometimes a call to us would be a good idea for us to kind of help somebody strategize how to make sure that their out-of-state order is enforced in Massachusetts.
Yeah, and registration is particularly useful if you don't think you're going to be able to keep a copy of the restraining order on you at all times, because you need to have the actual order. Whereas if it's in the registration system, a police officer can look it up in the database. All right, so now we're going to talk a little bit about keeping someone's address a secret. And there's a couple ways that we're going to discuss. The first is impoundment. So you can ask a court in any case to impound your address by filing a motion and an affidavit explaining why you want the address to be kept a secret. And this can also apply to phone numbers or other information that might help somebody locate you. It's not automatic, and it only applies in the case you ask for it in. So this means that if you get a restraining order with an impounded address and then go file a divorce, the divorce court isn't going to look up and see, oh, their address was impounded in this restraining order, so we're going to keep it secret here. You need to file it in every single case. There's no database or registry of whether somebody's had an impoundment. In order to do so, as I said, you'll file a motion, typically, and an affidavit. But the process varies a lot from court to court. So we advise that anyone who's seeking to do this should speak with the court staff of where the case is that they're seeking the impoundment and figure out what the process is going to look like it. In probate court, you'll often be expected to appear the day you go file the case for the first time, to go before the judge to explain why you want the impoundment. So plan accordingly. If you're filing a new divorce with an impoundment, somebody should be ready to have enough time to go before the court that day. You'll also need to serve the affidavit and the motion on the other party. This can be done after you file. And then frequently in probate court, and this varies again from court to court, you'll be expected to appear again, this time after notice to the other party, similar to how restraining orders are done, where you go have the first hearing, you get the impoundment, but then you have to come back a couple of weeks later, or 10 days later, or whatever the case might be, with the other party having a chance to object to the impoundment. So the key takeaway here is that there is a process, but that you should consult with the court about it to figure out the specifics, because it might depend. Another means to keep an address secret is to use the Address Confidentiality Program, or the ACP. This is a statewide program run by the Secretary of the Commonwealth, and it provides an alternate address for mail that a survivor can use to register with state programs like the RMV, or in filing court cases and other things like that. Essentially, you get a new fake address that sends mail to the RC or the ACP program itself, and the folks there will forward the mail to your actual address. In order to apply, a survivor needs to get the assistance of a certified application assistant. So there's certain people that are qualified to submit the application. You could find more information at this link at the bottom on the mass.gov webpage, or if you just search for Address Confidentiality Program, Massachusetts, you can get some information there. It's notable that you can't just apply to make your address confidential at any time. It needs to be either when you're in contemplation of an upcoming move or have recently moved before the address is disclosed to whoever you might be trying to keep it confidential from. So it's important to consider the timing. And if you're advising a survivor about this program, they should be thinking about it in conjunction with when they move.
So yeah, just some notes. So when you refer folks to us, so we're only licensed in Massachusetts. So if somebody is moving between Vermont and New Hampshire, we're not barred in those states. We're not able to give advice. However, we can, we have a directory of legal services in other states. We can provide referrals. But unfortunately, we can't practice the law in all 50 states, just this one here. And also just as we reiterated, we're lawyers. Our role is to make sure that somebody understands their rights and obligations under the law. We understand that fleeing is the most dangerous time for a survivor, and subsequently there's a lot of nuance that goes into somebody's decision to flee and how to flee, and that there's a lot of safety planning in line, and that often our legal advice might seem at tension with somebody's safety. This is a nuance we're aware of, but again, we're lawyers, and we think that there's a value in understanding what your rights and obligations are, and that is our role. But we point that out because sometimes we understand that survivors are facing these often impossible choices, and which is why we think it's so important to partner with domestic violence advocates in the community like you guys in order to help folks best navigate how to keep their family safe and to follow them.
Great. So we had prepared some questions that we wanted to ask folks who are here. And then also sort of open it up for any questions you guys might have for us. I'm not sure if people are comfortable being recorded, so maybe I'll end the recording now and we can just sort of chat as long as you guys want. And maybe do a little bit of back and forth communication.
It's a pretty small group, so we can also just kind of leave this as the informal question time, if that's helpful. But we would really like to hear from you about like some of these questions that are up, and what are you seeing in the community with survivors?
All right, I'm going to stop sharing because I think that's how I need to